station, 1370 WOCA.
Ocala.
All right, it is 25 minutes before 11 o'clock. Thank you for tuning in this nice, really, even though it's snowing everywhere else, nice Wednesday morning. It is time for Legally Yours. This is the program hosted by John B. Fuller. He is an attorney here in Ocala at the law firm of Fuller & Fuller, and he comes into these studios each Wednesday to answer your questions about the law, maybe a circumstance you are involved in. And the phone number to call is 622-9622. That is 622-WOCA, the WOCA Climate Control Source Hotline. And I need to tell you the date so you know if it's a live show or not. And today is Wednesday, February 5th, 2014. Good morning, John.
Good morning, Larry. Good morning to all our friends who are listening. Glad to be here. Glad it's not snowing. And yesterday was picture perfect. I'm sure a lot of our northern visitors were relishing in our springtime weather. But it's nice to be here, and hopefully we'll get some interesting calls.
You got a few waiting for you already. Wow,
very good.
They came in quick today. All right, good morning. You're on there with John.
Good morning.
Good morning. This is Kathy. Hi, everybody.
How are you, Kathy?
Thank
you for calling.
The difference between civil and criminal law, basically.
Okay.
I'm just try to be as concise as I can. My neighbors had an antique clock they valued very much, and they responded to an ad where the repairman came to their home and took the clock and took it to his home to be repaired. Much too much time passed. They'd called him, got in touch with him once, and then he would not respond to any calls. So they decided to go to the law and file a theft report. And they said, we're told it was a civil case, not a criminal case. Why would that be?
Well, I'm not really sure. Sometimes the distinction is a little bit blurred. I think in all candor, sometimes law enforcement, if there is a potential civil component and it's a relatively modest issue, they don't want to be bothered with it, and they refer it to civil courts. I've had several cases, not recently, not necessarily even in this jurisdiction, so I'm not implying criticism of any of our local officials, where my client hired a forensic accountant and determined that an employee had stolen a lot of money. They put together all of the source documents that established it and went to the law enforcement and ultimately to the state attorney's office. Again, I'm not specifying any jurisdiction, and showed the evidence of it, and was told, you have your civil remedies, and you need to pursue those. One of the things that makes it gray is whether or not it was permissive. In other words, if the employer or if the individual you're calling about, they entrusted the item with the individual.
Right.
The question becomes, was there a time frame specified for how long it was to take to repair the clock? Where do you draw the line between the permissive surrendering of the clock for the purpose of being prepared versus the clock being converted to the other person's wrongful ownership? These are very gray areas, and law enforcement, they have tight budgets, and they've got a lot of cases to deal with, and this person has a remedy. They can go sue for conversion, which means that he wrongfully took the clock and they get damages for it. They could file a suit for a writ of replevin, which means it's their property and it's wrongfully in his possession and they want it back. And the judge will determine who's right and who's wrong and make a ruling accordingly. So civil law deals with disputes over property, interpersonal relationships, accident cases, things like that. But there's an overlap. If Party A hits Party B with his fist, Party B may sue that individual for civil assault and battery and seek damages for his medical bills, injuries, lost employment, pain and suffering, and so forth. Out of that same act of Party A hitting Party B, there is also a coexisting crime, because it is a criminal offense to hit somebody, to touch somebody without their permission. So you can have a criminal case and a civil case that are proceeding simultaneously involving the same parties and the same set of facts. And in the civil case, you get money damages. In the criminal case, if convicted, the judge can punish the person by incarceration.
Right.
I hope that's helped.
Okay, well, thank you. I appreciate that.
My pleasure. Thanks for calling.
All right,
Thank you. And we have another phone call. Good morning. You're on the air with John.
Good morning, Mr. Phil.
Good morning.
I have a simple question. If you name an executor of a will, or, to handle a will, do they have to know what's in it and who's getting what beforehand, or can they be surprised like everybody else? I'll hang up and listen. Thank you.
Okay. All right. Well, as I have said many, many times on this program, any questions involving wills, estates, trusts, and probate, I want to express a caveat that I do not specialize in that area, and it's not an area of the law that I have specialized knowledge of. Generally speaking, and under all states have their individual statutes that deal with wills, trusts, that sort of thing, and every state can have different laws. So based on Florida law, we don't call the person who administers an estate an executor anymore. It used to be that used to be the term that was used even when I was in law school in the early 70s. Now, under our probate code, the individual is referred to as the personal representative, who is charged under the law with the fiduciary duty once someone dies and they're named the personal representative to marshal that person's assets, to collect all the assets, to determine what are the lawful debts based upon claims of creditors, to see that the lawful debts are paid, to determine whether or not there's any estate tax liability, and to see that you get a non-taxable letter or a letter of discharge from the federal government after filing a Form 706, which is an estate tax form if the estate is large enough, and then to distribute the remaining assets, items, personal property, real estate, whatever, to the beneficiaries named in the will, so that the decedent's wishes are complied with, and then to have an accounting and seek discharge from the probate judge once those things have all been done. An individual, you can name anyone in your will that you want to, and you don't have to have advanced permission to name them in the will. However, as a practical matter, it would be very good idea, in my opinion, that if you're going to name an individual to be your personal representative, especially if that individual isn't your spouse or your son or daughter or some family member, if you're going to name an individual to be the personal representative, you ought to call that person up and ask them, would you be willing to accept this responsibility of being the personal representative of my estate in the event I predecease you?
Right.
Would you be willing to take on this burden of doing this work? The statute also provides that the personal representative is entitled to be paid a personal representative's fee out of the funds in the estate. But sometimes people will say, well, I live in another state. That would be too much of a burden.
Right.
I don't want to do it. Or I'm not in good health and I don't feel like I could accept that responsibility. Well, if you know ahead of time that person is going to decline to serve, you can't make them serve. You appoint them, but when it comes time for the court to appoint them after your death, they can decline. Whenever you do a will, people always should name a personal representative and an alternate personal representative in the event, for whatever reason, personal representative number one cannot serve, will not serve, and there's a possibility that the named personal representative may have died before the person who made the will did.
Right.
If, in fact, that occurs, you need to call up your lawyer who prepares your will and say, I need to come in and amend my will with a codicil or do a new will because the individual who I wanted to be my personal representative was killed in a car wreck last week, and I need a new personal representative appointed. So it's important to review your estate plan periodically to make sure that it is current and is doing the things that you want done and the way you want it done after your death.
And if I could just add my 2 cents, because I was the personal representative after my mom died, and my reluctance, I mean, I knew it was coming, and I just thought, gosh, I hope I'm not like bombarded with legalese and things that I'm just going to have a trouble with. And it was the attorney. I mean, it was as easy as could be because I basically was the representative, but my attorney really kind of took me by the hand.
And that's the way it always is, or always should be. The personal representative may have some legwork to do, such as compiling documents or things of that nature.
Right.
But the administration of the estate is a legal function. And you need to hire a good estate attorney who will file the petition for admission of probate, to probate the will file the notice of to creditors in the newspaper to extinguish the time for claims, and will take care of these things. If it's a large estate, you will need an accountant to do an estate tax return.
And you have another phone call.
Very good.
Good morning. You're on the air with John Fuller.
This is Sonny again. I don't know if you answered it or not. Does the representative have to know what's in the will before the reading of the will or the execution of the will or whatever it is?
I misunderstood you.
Place?
Yeah. Okay. You're right. Thanks for calling back, because I did not appreciate that was the question. The personal representative cannot administer the will without reading it and knowing what is in it. So to answer your question, I don't know of any circumstance where you could have a personal representative appointed to administer a last will and testament and keep the provisions of the last will and testament secret from the personal representative.
Prior to the death?
Prior to the death, yes. After the death, no.
Okay. So I think that's what he was asking.
Okay.
I think he meant...
Well, yeah, and personal representative, he doesn't even see the light of day until the person dies and the will is being probated. So, yes, you can. He does not have a right to see the will. That is your personal privilege, confidential document. I would recommend, as I previously did, that you check with the individual to see if they would serve if named. But you have absolutely no requirement, and they have no right to see the will ahead of time or to know what's in the will. And in fact, if they agree to be personal representative, you may amend your will 3, 4, 5 times before you actually die, and that personal representative comes into the picture. So no, your will is private, it is confidential, and no one other than you and your lawyer, who's bound by the rules of privilege, should know what's in the will.
The phone line is open if you'd like to call John with a legal question. The number is 622-9622. Today is Wednesday, February 5th, 2014, just so you know if it's a live show or not. And may I give you an update on my circumstance I told you about real quickly?
Absolutely.
Remember I told you I paid a 50% down payment on a guitar,
and
which was
they
$300.
Said the model you were buying was blemished and they couldn't get it right. But they'd sell you a lesser one for lesser money or something, and you never heard from them.
Right. So I kept asking and asking and asking for the $300 back. Well, remember I asked you about it, which was the extent of our relationship regarding that.
Right.
I wrote him a letter, and I said, this morning I spoke to an attorney about our circumstances.
Appropriate.
And I would appreciate you sending me a refund. That's all I said. I didn't lie.
Right.
I didn't say I
Absolutely
retained
not.
you. I just
No problem at all.
Guess
Yep.
what happened? I got the refund like in a day.
That is awesome. Well, it's
The
a
power
shame.
of telling somebody you have an attorney on your side.
Well, the beauty of our legal system is it gives you a tool to protect yourself against unscrupulous people. And the fact that you were in the process of availing yourself of a representative, I'm glad it was motivational in getting your money back.
Can you believe that? So
It happens a lot.
All right, let's go to the phone. Thank you for waiting. You're on the air.
Hey, listen, I'd like to ask you a question.
Okay.
If wife has a 26-year, premarital agreement, I would like to know, just to basically, is that illegal or legal after 26 years marriage is still in force?
Premarital agreements are enforceable in Florida. It is a complex analysis to determine if they are valid or invalid, if they are challenged. There was a standard that was used to determine validity based upon an appellate court decision known as Casto versus Casto that governed the determination and the elements that must be complied with in order to have a valid prenuptial agreement if that agreement was prepared prior to 2007. If the agreement was prepared after 2007, there's a different standard under the Florida statute that superseded the Casto case and provided a new set of standards and rules for how the judge examines and determines whether or not a prenuptial agreement is valid. If prenuptial agreements are properly prepared in compliance with either the requirements of Florida law as it existed pre-2007 under the Casto case doctrine, it's enforceable. If it complies with the standards of the statute that was adopted by the legislature in 2007, it is enforceable. These legal issues of what is the analysis that goes into it is quite complex and would take far more time than we have at this radio call-in program for me to even begin to explain it. And it's dependent upon the facts of the circumstances of how the agreement was negotiated and ultimately agreed to. And if there is a question concerning the validity and enforceability of a prenuptial agreement, the person who has the agreement, whether they are seeking to enforce it or they are seeking to have it declared invalid, obviously need the assistance of a lawyer.
Well, another thing, though, is the lawyer made it up. And another thing, I photographed, took the newspaper at the time and the date, took a camera and set it up, and then I sat there and I read off my agreements. Plus, what's happening is I have 3 boys that had ancestors and they're involved, and I had a lot of money involved in it. I don't want anything in her family to get any of this money because they're not worth anything. They're nothing. She's taken care of. Automatically, I took care of her until her death. But it seems like they've been. I don't want to be involved with them at all because they're just not worth that much. They're not worth anything. And I have my own family. So all I need to know is that basically I have a videotape of me reading off a will. I read the will off, and then I pointed the person in charge of it.
Well, you've mixed and matched inconsistent questions. You've talked about a prenuptial agreement, is the way I understood it. Now you're talking about a will, and you've got a complex situation. Prenuptial agreements only apply between a husband people who are contemplating marriage and ultimately become married and a husband and a wife. It doesn't apply to friends, relatives on either your side of the family or her side of the family. That is controlled by a will and the Florida probate code. Either way, sir, you're not going to be able to get a meaningful answer to a complex question that involves multiple issues. And even though you say you read it off and you had it videotaped, you had it in a newspaper, if the agreement isn't valid under the requirements of Florida law and it was done in Florida, it's at risk for being held invalid. If it is otherwise valid with compliance of the requirements of Florida law, it is enforceable. But I don't know whether you're talking about a will or whether you're talking about a prenuptial agreement. And the best I can tell you on a radio call-in talk show is that you have a legal issue that needs to be analyzed by a competent attorney who would give you an opinion on what your legal position is concerning that agreement and whoever may be trying to assert some kind of claim against you.
Well, that's fine. I appreciate the answer, but there's both things involved.
Well, that's like I said. This is your situation. Your situation is one that is going to be dependent upon the unique facts and circumstances, and there are elements and questions that you are not aware of that need to be analyzed, and it's complicated and it's complex, and you need to have it. You need to take all your paperwork and have a meeting with a lawyer who would review it, analyze it, do the necessary research to formulate a valid legal opinion based upon the law as it applies to the facts of your case and your documents. And that's really the best I can help you with.
I thank you. You're doing a good job.
Thank you. I appreciate you calling, and please do follow up because you know that's the only way to get the right answers.
Yeah, it sounds like maybe a visit to your office would be.
Well, we'd be happy if a person wants to schedule an office conference and retain us to review and analyze and give a specific legal opinion on a specific set of facts. Certainly, we'd be open to do that. And our local telephone number is 352-547-4292. But it's not something that you're going to be able to answer over a talk show.
Complex.
I wouldn't try to answer it over a telephone conference, and I wouldn't probably try to answer it after the first office conference because you need to research the law as it applies to the facts of each case.
Call us, please, at the radio station if you need John's phone number repeated. We realize that when we do these shows, you're probably out in your car or maybe can't write the number down or we read it too fast to you or any of the above. You're always invited to call us here at the station and ask us to repeat it slowly for you so you can write it down. But plus there was an emotional element in his what he was telling you, and I'm guessing that plays a factor. From your perspective, you have to kind of work your way through that and see. Am I right about that? When you're working with somebody?
Well, you have to really get the true facts. And you have to get all of the facts. Yeah. And you have to then look at the documents, and you have to then research the applicable law, and then apply that law to the facts that involve your client. That's what lawyers do, and there's no substitute for thoroughness and doing a good job. The elements to, you could have a prenuptial agreement. One quick little vignette. If you have a prenuptial agreement and it's in writing, and you have disclosure of your financial records attached, but you don't tell the prospective bride, that you want it, and she doesn't otherwise know about it, and she doesn't know anything about your assets, and on the way to the church, you hand her this agreement and say, if you don't sign it, there won't be a wedding. There is a strong likelihood that agreement would be set aside for undue duress, coercion. because there is inadequate time, and it's inherently embarrassing that if you don't sign it under this compunction, that you're going to be embarrassed because all of your friends and family are waiting at the church, and the champagne's cooling, and all the gifts have been received, and the flowers are there, and the invitations sent out, and the bridesmaids are there, all dressed up in their fancy dresses, and the groomsmen are there in their tux, and 15 minutes before the wedding, you hand this 40-page prenuptial agreement and said, either sign it or I'm walking, and you have that right to do that. You have the right to cancel the wedding and leave, but if she signs the agreement, even though the agreement is properly drafted, it sets forth the terms, you make disclosure, it's probably going to fail for duress.
So what if you did sign it and then you, the one who signed it, said no marriage? I'm not getting married.
All prenuptial agreements do not become operative until the people get married.
Oh, okay.
So if she signed it and you said, I just don't want to go through with this, goodbye, have a nice life, there is no marriage. The document is of no force and effect because it only comes into effect if there is marriage. It is an agreement that is made in contemplation of marriage.
And it is a red flag, isn't it, that somebody just might not be the right person for you?
Well, I think that gets into more Dear Abby type of analysis than I'm capable of doing. It's not a good start, the scenario I just told you. And that's an actual case where that actually happened, and it was in the Fifth Circuit Court of Appeals, tried by Judge Alls down in Lake County, and went to the Fifth District, and it said when a premarital agreement is given to the bride-to-be, or it could be groom-to-be, doesn't matter, on the eve of the marriage, that it is presumed to be undue influence under those circumstances.
Can I squeeze in one last question? Just a little bit of.
Well, I would mention one thing that I meant to bring it with me. There's an article in this morning's paper, local paper, about the number of prosecutors and law enforcement officers across the country, not necessarily here, who have joined together to re-examine criminal cases where people have been convicted, and there has been an impressive number of people who have been convicted who are being exonerated because they were improperly convicted after jury trials, and I commend law enforcement for doing that. Too many times in the past, I think it's been the state, the prosecutor, the U.S. government, the U.S. attorney, they have a duty to see that justice is done. Their duty is not to get a conviction at all costs. And I'm glad to see them taking the initiative to go back and revisit these cases, because even though our system, I truly believe, is the best system in the world, it isn't perfect, and mistakes are made, and sometimes they're made because of either incompetence in the law enforcement or the prosecution, or because of corruptness. There was a big article a few days ago where a chemist may have compromised thousands of drug cases because he was substituting the controlled substance that was in the evidence locker with an over-the-counter substitute, and presumably, I don't know what the facts are, but from the article, presumably he was disposing of it for monetary gain, and those cases are all now compromised.
Oh, man.
And there was a case involving the Florida Department of Law Enforcement in this area 10 years ago or more, where a number of cases were dismissed because of improprieties in the chemistry lab by one of the chemists. So that's what a criminal defense lawyer's job really is, and that's to go challenge the evidence. Because just because it's evidence and some law enforcement officer or prosecutor wants to rely upon it, our system says the validity and the probity value of that evidence is subject to rigorous cross-examination and rubbing and scrubbing to see if it's true and accurate and probative.
All right. Thank you for another great show, John.
And thanks all our callers. We had a lot of nice, interesting calls today from listeners, and we appreciate that.
And could you one more time, please, give us your phone number and how else we get a hold of you?
Yes. We're at the law firm of Fuller & Fuller. Our local phone number is 352-547-4292. Our toll-free number is 855-534-2565.
And call us if you need that repeated. John, thank you for another great
Larry.
show. All right, we will move forward, take a little break, and be right back.
Wow. That was...
Ocala's information station, 1370 WOCA.
Ocala.
ABC News Now. I'm Karen Chase. President Obama, a former smoker, says CVS's decision to stop selling cigarettes sets a powerful, healthy example. The drugstore says selling tobacco products goes against its goal of keeping customers healthy. Winter weather continues to tangle